Hello, everyone, and welcome to One Civil Law. I hope you're having a great day. For today's story, we are going to be covering the Trump tariff loss at the U.S. Supreme Court. As I'm sure you're well aware, Donald Trump imposed all kinds of tariffs, and I didn't think he had the authority to, because the Constitution of the United States grants the authority to create tariffs to Congress, and, not so much. He just didn't have authority, so it's kind of that simple. He tried to quote some language, and he obviously stretched the language well beyond what it had to say. And so, I'm completely unsurprised by this in a 6-3 decision by the Supreme Court. I'm only surprised, I guess, that it's 6-3. We may or may not read the dissent depending on our time availability. But let's see what the opinion is, and we'll read it and discuss it for all of its beautiful, beautiful value. Great. We are in the United States Supreme Court in the case of Learning Resources, Inc. versus Donald Trump and Donald Trump versus VOS. So there were two cases that were argued and consolidated for the purpose of the opinion. I believe they were argued separately, but they're provided one opinion. So fair enough. We decide where the International Emergency Economic Powers Act authorizes the president to impose tariffs. Shortly after taking office, President Trump sought to address two foreign threats. The first was the influx of illegal drugs from Canada, Mexico, and China. The second was a large and persistent trade deficit. The president determined that the first threat had created a public health crisis, and the second had led to the hollowing out of the American manufacturing debate and undermined critical supply chains. He invoked authority under statute to respond. Enacted in 1977, the statute gives the president economic tools to address significant foreign threats. When acting under the statute, the president must identify an unusual and extraordinary threat to the American national security, foreign policy, or economy, or originating primarily outside the United States, and he must declare a national emergency under the National Emergencies Act. He may then, by means of instructions, license, or otherwise, take the following actions to deal with the threat: investigate, block during the pendency of the investigation, regulate, direct and compel, nullify, void, prevent or prohibit any acquisition, holding, withholding, use, transfer, withdrawal, transportation, imposition of or exportation of, importation of or exportation of, or in dealing with, or exercise of any right, power, or privilege with respect to, or transactions involving any property in which any foreign country or national thereof has interest. President Trump declared a national emergency as to both drug trafficking and trade deficits, which he deemed unusual and extraordinary threats. Right away, I'm kind of dubious. He then imposed a tariff to deal with each threat. As to drug trafficking, the president imposed a 25% duty on most Canadian and Mexican imports and 10% duty on most Chinese imports. As to the trade deficit, the president imposed a duty on all imports of all trading partners of at least 10%. Dozens of nations faced higher rates, and these tariffs apply notwithstanding any extant trade agreement. Since imposing each set of tariffs, the president has issued several increases, reductions, and other modifications. 1 month after imposing the 10% tariff, he increased the rate to 20% for China. 1 month later, he removed the statutory exemption for Chinese good under $800. The de minimis rule, which is just a major pain in the ass, by the way, just for everybody. Getting rid of the de minimis rule is just a pain in the ass. Less than weeks after imposing the reciprocal tariffs, the president increased the rate on Chinese goods from 34 to 84. The next day, he increased the rate further to 125. This brought the effective total rate on most Chinese goods to 145%. The president also shifted sets of goods in and out of reciprocal tariff frameworks. Petitioners in Learning Solutions and respondents in VOS filed suit alleging the relevant law does not authorize the president to issue reciprocal or drug tariffs. The Learning Resource plaintiffs, two small businesses, sued the United States District Court for District of Columbia. The VOS, we're gonna get rid of the procedural history because we don't need that. Okay, let's get rid of the procedural history. Great. Based on two words separated by 16 others in section 17A, in 1702A1B of the law, regulate an importation. The presidents assert the power to impose tariffs on any import from any country of any product at any rate for any amount of time. Those two words cannot bear such weight. So this is basically the idea that this is sort of, I assume it's going to come down to major questions doctrine. I assume this is where this is going. And the idea that we don't hide mountains and molehills. When Congress wants the power to do something, they're not going to use a very general word to do a very massive thing, right? They're not going to say regulate. And what they mean by that is, the world, right? They're going to, they don't mean that. If they meant something stronger, they'd use a stronger word. They'd be more specific, right? So this is basically major questions doctrine. And it's a major question because it deals with tariffs and trade and the economy and international relations and so forth and so on. It's, the tariffs obviously are a pretty big deal. And the Congress has the power to regulate tariffs. So if they were going to give the power to the president to augment tariffs in this way, they'd probably use more specific language to that point. You're trying to cram a lot into not much. And so that's a problem. It was a problem under Biden, for example, when it came to regulations dealing with the vaccine under, CDC authority or under workplace safety authority. It was a problem there, and it's a problem here. So yeah, I think that's probably where this is going, and that makes sense to me. Article 1, Section A of the Constitution sets forth the power to the legislative branch. The first clause of that provision states the Congress shall have the power to lay and collect taxes, duties, imports, and excises. It's at no accident this power appears first. I don't know if that has anything to do with anything, but whatever. The power to tax was, in Alexander Hamilton's explained, the most important of the authorities proposed to confer upon the Union. It is a power to destroy and a power to necessarily to existence and prosperity of the nation. The one great power upon which the whole national fabric is based. Okay, fair enough. The power to impose tariffs is very clearly a branch of taxing power. A tariff is a tax by another name. A tariff, after all, is a tax levied on imports. It sure is. And tariffs raise revenue, the defining feature of a tax. Indeed, the framers expected the government would for a long time chiefly depend on tariffs for revenue. Maybe. Not a bad idea, but Congress's idea, because Congress is the one that sets taxes. Little wonder then the first Congress first exercised taxing power and its second enacted law, right after the one providing for new officials to take the oath. Nice. Was a tariff law. That's good. That's cute. First one is, here's how you become an elected official. Second one is tax. I like that. Recognizing the tax's unique importance and having just fought a revolution motivated in large part by taxation without representation, the framers gave Congress alone access to the pockets of the people. They required all bills for raising revenue to originate in the House of Representatives. In doing so, they ensured that only the House could propose the supplies requisite for support of the government, thereby reducing all overgrown prerogatives of the other branch. They did not vest any part of the taxing power in the executive branch. Truth. The government thus concedes, as it must, that the president enjoys no inherent authority to impose tariffs. Yep. That's pretty clear. And does not defend the challenge of tariffs as an exercise of war-making powers. The United States, after all, is not at war with every nation in the world. Cute. The government instead relies exclusively on this statute. It reads the words regulate and importation to effect a sweeping delegation of Congress's power to set tariff policy, authorizing the president to impose tariffs on a limited amount of duration on any part of the country. Yeah, no, right away you're in trouble. Right? This is just major questions doctrine. I'm sure this is where this is going. This is major questions through and through. Right? We do not hide mountains and molehills. We do not give massive, sweeping authority through words like regulate and import. Right? This is, if we were going to do this, Congress was not going to hide the ball. They would say it. They would say, the president has the power to increase and decrease or establish tariffs. They wouldn't hide the ball in this generic language. You are trying to do too much with too little. You're trying to fit 10 pounds of shit in a 5-pound bag. Not happening. I'm here for major questions doctrine. because it keeps the executive in check. It prevents Biden from doing bullshit, and it prevents Trump from doing bullshit, and I'm here for it. Also, it means Congress actually has to do its job. What a nice thought, right? We do have our balance of powers, as we should, and the president has his powers to run the executive branch, as he should. I'm in favor of the unitary executive. I believe the president of the United States is the executive branch. That's, after all, what Article 2, Section 1 says. The president is the executive branch himself, personally. Great, but he's only the executive branch. He's not also the legislative branch. So he can only do the executive branch stuff. He can't create new taxes. No, not so much. Not for you. That's for, make Congress actually do their job. That'd be great. That's not what the Supreme Court's saying at all. I guess we'll find out if that's what the Supreme Court is saying. I'm reading the opinion as we speak. I feel that's probably where they're going. That's probably the logical way they're going. But if that's not what they're saying, I guess we'll find out real fucking fast. Necrotic, I'm reading it and explaining it as we go. And I'm like, oh, I think this is probably where they're going. They're probably going to major questions doctrine because that makes sense. But if that's not what they're doing, if they're not doing major questions doctrine, if they're doing something else, then I guess we'll find out together. Let's find out if they're doing major questions or not. Because that sounds a lot like where they're going. Let's find out. We have long expressed reluctance to read ambiguous statutory text, extraordinary delegations of Congress's power. It's either that or non-delegation doctrine. It's one of the two. It's either major question or non-delegation. In Biden versus Nebraska, for example, we declined to read authorization to waive or modify statutory or regulatory programs applicable to financial assistance programs as delegation of power to cancel $340 billion in debt. In West Virginia versus EPA, we declined to read authorization to determine the best system of emissions reduction as delegation of power to force a nationwide transport away from coal. And in National Federation of Independent Businesses versus OSHA, we declined to read authorities to ensure safe and healthy working conditions as a delegation of power. We've described several of these cases as major question cases. I don't know, man. I don't know. They just used the words major question. You said that's not what the Supreme Court's saying? I don't know, man. They just said major questions just now. I think that might be where they're going. I don't know, man. Well, I guess we'll find. We've decided several of these questions as major questions cases. In each, the government claimed broad, expansive power on uncertain statutory basis. In each, the statutory text, as a matter of definitional possibilities, has been read to delegate the asserted power. But the context counseled skepticism. That context included not just other language within a statute, but constitutional structure and common sense. Both separation of power principles and a practical understanding of legislative intent suggested Congress would not have delegated highly consequential power through ambiguous language. That sounds a lot like what I was just saying before. So that sounds like the same thing I was saying to me. These considerations apply with particular force, whereas here, the purported delegation involves core congressional power of the purse. Congress would likely intend for itself the basic and consequential trade-offs inherent in the uses of the most complete and effectual weapon. And if Congress were to relinquish that weapon to another branch, a reasonable interpretation would expect to do it clearly. Oh, they're going to do it clearly, directly, and unmistakably? Oh, that sounds, again, like a lot of what I was saying. It sounds like the same thing I was saying. When common sense suggests, congressional practices confirms when Congress's delegated tariff is done so in explicit terms and subject to strict limits. Congress is consistently uses words like duty and statutory delegating authority to impose tariffs. It has capped the amount of duties and tariffs, and has conditioned the exercise of tariff power on demanding procedural prerequisites. Against the backdrop of clear and limited delegations, government reads the relevant law to give the presidential power unilateral power to impose tariffs. On this reading, moreover, the president is unconstrained by significant procedural limitations in other tariff statutes and free to issue a dizzying array of other modifications at will. All it takes to unlock that extraordinary power is a presidential declaration, which the government asserts is unreviewable. And the only way of restraining that exercise of that power is a veto-proof majority in Congress. That view of credit would represent a transformative expansion of president authority over tariffs policy because it would basically allow him to do anything. If the power is unreviewable, and it gives him this authority, then the president just can do anything on tariffs at any time by sheer whim. So probably not that, no. And indeed, is demonstrated by exercising authority in this case over the broader economy as well. It would replace the long-standing executive legislative collaboration of trade policy with unchecked presidential policymaking. Congress seldom effects such sea changes through vague language. Again, this is exactly what I said they would say. Isn't it? I mean, this is exactly what I was describing. This sounds, when I said this sounds like where they're going, now that's where they're going. Yeah, this is exactly what they're doing. Yeah, this is, who was it who said that's not what the Supreme Court's saying? I'm pretty sure it's what the Supreme Court's saying. I mean, I'm reading it. I mean, again, I read a lot of these cases. I know how the Supreme Court thinks because I read a lot of these cases. I'm like, yeah, this is probably where they're going. This is why they're setting this up. And I'm like, yep, that's where they're going. Sounds right to me. Yeah. It's also telling that the statute's half-century of existence, no president has invoked the statute to impose any tariff, let alone tariff of this magnitude and scope. Presidents have, by contrast, regularly invoked the law for other purposes, and by the same time, they've invoked other statutes, but never this law, to impose tariffs on products ranging from car tires to washing machines. Sure. And those tariffs do not even begin to approach the size or scope of the relevant statutes here, or the relevant tariffs here. The lack of historical precedent for the tariffs, coupled with the breadth of authority the president now claims, is a telling indication that tariffs extend beyond the president's legitimate reach. The economic and political significance of the authority of the president has asserted likewise provides a reason to hesitate before concluding Congress meant to confer such authority. The president's assertion here is a broad statutory power over a national economy is extravagant by any nature. As the government admits, indeed boasts, the economic political consequences of the tariffs are astounding. The U.S. government's about to have to write a big check. Yeah, the government's about to have to write a big check. I hope they have their checkbook handy because they owe someone some refunds. In fact, they probably owe me money. Now that I think about it. Because when I imported my watch from Japan, I paid a tariff. The U.S. government owes me some money. Write me a check, bitch. And the government indeed boasts the economic political consequences of the relevant tariffs are status. The government points to projections that tariffs will reduce the national deficit by $4 trillion. International agreements reach the reliance of tariffs could be worth $15 trillion. In the president's view, whether we are a rich nation or a poor one hangs in balance. These stakes dwarf those of other major questions. As those cases, a reasonable interpreter would not expect Congress to pawn such a big-time policy call off on another branch. Hey, U.S. government, better have my money. Where's my money? Where's my money? Give me my money. Where's my money? The government and principal dissent attempt to avoid application of the major question doctrine on several grounds. None is convincing. The government argues first the doctrine should not apply to emergency statutes. Oh yeah, that definitely makes sense. Yeah, let's let not apply to emergency statutes. There's no way that's going to go wrong. Lord have mercy. But the argument is nearly identical to the one already advanced in Nebraska. There, the government contend that a different emergency statute should be interpreted broadly, because the whole point was to provide substantial discretion to respond to unforeseen emergencies. We reject the argument in Nebraska and reject it here as well. Emergency powers, after all, tend to kindle emergencies. Preach it, baby, preach it. Yeah, if you give the government the emergency button, press here to do whatever you want, what do you think is going to happen? Yep. Dozens of relevant emergencies remain ongoing today, including the first declared over 4 decades ago in response to the Iranian hostage crisis. That Iranian hostage crisis, hopefully that'll be resolved any day now. And the framers understood emergencies can afford a ready pretext for usurpation of power. No. When Congress has reason to be worried about power slipping through its fingers, we have in turn to have every reason to expect Congress to use clear language to effectuate unbounded delegations, particularly of its one great power. Yeah, Yeah, this liberal loves this. Yeah, well, this conservative loves this. Yeah, I love this as a conservative. Yeah, I believe in the Constitution. I actually believe in the Constitution, and I believe in separation of powers. I believe in a unified executive, and I believe in a president that is the executive branch unto himself, just the guy. Yeah, the guy is the entire executive branch. That's what the Constitution says. So that's what it says. But that only gives him executive power. So, I mean, that's a lot of power to be sure, but it's not all the power. It's all the executive power, but it's not all the legislative and not all the judicial power. Those are different things. Right. So it's like, yeah, this conservative loves this too. And because, of course, I want this to apply to all presidents. That's the key. Right? That's the key, right? That's why it's like when this was Biden trying to do this bullshit or similar bullshit through OSHA or the CDC, or, when Biden was trying to do this bullshit through the CDC or OSHA, or let's cancel all the student loans, right? When Biden was trying to do that bullshit, I'm like, I don't think so, Biden. I don't think so. You don't have any of that authority. Fuck you. And then, of course, when Trump is like, I want all the tariffs, I'm like, I don't think so, Trump. Fuck you. See, this is one of the great things about having consistent philosophical views, right? Because it doesn't matter to me if it's Trump or Biden, or I don't care if they're trying to do something I like or something I don't like. I don't fucking care. I just want to follow the law. The law is great. Let's follow the law. Hooray, law. It's fantastic. The conservative in me could not be more thrilled by this. This is fantastic. This is great. Let's do more of this. This is fantastic. Yeah. The government and its principal defense proposed foreign affairs exception bodes no better. As a general matter, of course, the president enjoys some independent constitutional powers over foreign affairs, even without congressional authorization. True, he's head of state. That makes him the chief diplomat. So he's head of state. He's the chief diplomat. He can basically recognize and derecognize countries on a whim. He can conduct quite a lot of international foreign affairs. That's true, but not so much with the tariffs. Not that. And Congress certainly may intend to give the president substantial authority and flexibility in many foreign affairs or national security contexts. You think it's broken? I'm not sure it is that broken. Yeah, you see, I think that this is exactly the opposite of proving it's not broken. Yeah, you say it's broken. I say no, it's not. I say it's working as intended. This is the opposite of broken. The branches are checking each other's authority. That was the entire point. Yeah, the entire point of separating the authority into things like the judicial, executive, and legislative branch was to have power check power. That was the idea. Power is, in fact, checking power. It's working exactly the way it's supposed to. And when any one branch of government tries to reach out and get outside of its lane, the other branches come in and whack it back into place. That was the idea. If everyone seeks power, then power checks power, and then no one can become too powerful. And it's great. I think the system is working pretty well. I love America. I love the United States of America. I love our country. I think our country is great. I think we live in probably the best country on the face of the earth. I say that non-ironically. I am proud to be an American. I love our system of law, and I love our system of government. It isn't to say it's perfect, but there is no perfect government. Our government is the worst except for all the others, and so forth and so on. This is the way it's supposed to be going. This is the government working. This is great. The Constitution, it remains alive. God bless the Republic. God bless the Constitution of the United States. Kick ass. The central thrust of the government and principal dissent proposes exceptions appears to be ambiguous delegations to statutes addressing the most major of major questions shouldn't necessarily be construed broadly. But it simply does not follow from the fact that the statute deals with major problems that it should be read to delegate all major powers from which there may be a colorable textual basis. It is precisely such cases in which we should alert to claims that sweeping delegations, particularly delegations of core congressional power, lurk in ambiguous statutory text. There is no major question exception to the major question doctrine. That's nice. Accordingly, the president must point to clear congressional authorization to justify his extraordinary assertion of power to impose tariffs. He cannot. To begin with, the relevant law authorizes the president to investigate, block during the pendency of an investigation, regulate, direct and compel, nullify, void, prevent or prohibit, importation or exportation. Absent from the lengthy list of powers is any mention of tariffs or duties. That admission is notable in light of the significant but specific powers Congress did go through trouble of naming. It stands to reason that Congress intended to convey the distinct and extraordinary power to impose tariffs. It would have done so expressly, as is consistently done in other tariff statutes. The power to regulate importation does not fill that void. Regulate, as the term is ordinarily used, means to fix, establish, or control, to adjust by method, rule, or to establish mode, to direct by rule or restriction. It is subject to governing principles or law. The definition captures much of what the government does on a daily basis. Indeed, if regulate is as broad as the principal dissent suggests, then 8 other verbs are simply wasted ink. That's true, because it would kind of encompass everything. Yeah, and we don't like to do that. We don't like to interpret words to make other words redundant. That is bad pool. Every word should be given due meaning. So we do not favor an interpretation that would render other words superfluous or superfluous, depending on how you like to pronounce it. Superfluous. We don't like to do that. So to the extent that you are saying, okay, this is what regulate means, and then we're like, well, if you interpret regulate that way, it would swallow everything else. Yeah, then it probably doesn't mean that. So yeah. But the facial breadth of regulate places in stark relief what term is not usually used to include. Taxation. The U.S. Code is replete with statutes granting the executive authority to regulate someone or something. If the government cannot identify any statute in which the power to regulate includes the power to tax, the government concedes, for example, the Security and Exchange Commission cannot tax the trading of securities, even though it's expressly authorized to regulate the trading of securities. We are therefore skeptical that this law, and this law alone, Congress hid the delegation of the birthright power of tax within the what is this word? Quotidien power to regulate. I don't know that word. What does that word mean? Quotidian of or occurring every day, daily, ordinary or everyday, especially mundane. Quotidian. Okay, well, there's your word for the day. Quotidian. Especially within the quotidian power to regulate. Taxes, to be sure, may accomplish regulatory ends, but it does not follow that the power to regulate something includes the power to tax it as a means of that regulation. Congressional power suggests as much. Thank you. It's me, Tony, for the memberships. It's appreciated. When Congress addresses both the power to regulate and the power to tax, it does so separately and expressly. That is unsurprising, as the power to regulate commerce is entirely distinct from the right to levy taxes. That Congress did not grant those authorities separately here is strong evidence that regulate in this relevant law does not include taxation. A contrary reading would render the relevant law partly unconstitutional. The relevant law authorizes the president to regulate importation or exportation. Taxing exports, however, expressly forbidden by the Constitution. The neighboring words with which regulate is associated also suggest that Congress did not intend for regulate to include revenue-raising power. Regulate is one of 9 verbs listed in the relevant law. Each authorizes a distinct action the president might take in sanctioning foreign actors or controlling domestic actors engaged in foreign commerce, blocking imports, for example, or prohibiting transaction. Presidential practice under relevant law demonstrates as much. None of the relevant authorities includes distinct and extraordinary power to raise revenue. And the fact that no president has ever found such power in the relevant law is strong evidence that it does not exist. We do not attempt to set forth the mean and bounds of the president's authority to regulate importation under the relevant law. The interpretive question is not an issue in this case, and any answering would be plain dicta. Our task today is to decide only whether the power to regulate includes tariffs, and it does not. Fair enough. The government echoed point for point by the principal dissent, marshals several arguments in response. First, it contends the relevant law confers the power to impose tariffs because early commenters and this court's cases discussed tariffs in the context of the Constitution's Commerce Clause. But that answers the wrong question. The question is not, as the government would have it, whether tariffs can ever be a means of regulating commerce. Instead, whether Congress, by conferring the power to regulate, give the president the power to impose tariffs. Yeah, so the question isn't whether taxing can be a means of regulation. That isn't exactly the question. The question is whether regulate includes the power to tax. Does the word regulate include the power to tax? Now, apparently it doesn't in any other statute. And it doesn't, and, Congress, when they've meant tariff or duty, have used those words. So it isn't that a duty or tariff can't affect a regulation or regulate. I mean, regulate just means to control something, right? So does a tax control something? I guess. But the question isn't whether or not a duty or tax can affect a regulation. The question is whether the word regulate includes the power to tax, and it does not. So not so much. And Congress's passage of the pattern of usage is the most relevant to answering the question. The pattern is plain. When Congress grants the power to impose tariffs, it does so clearly and with constraint. It does neither here. Yeah, so this is just major questions doctrine through and through, and I am 100% here for it in every possible way. The government raises another contextual argument. Because regulate lies at two poles in the relevant law, compel on the affirmative end and prohibit on the negative end, the term naturally includes less extreme, more flexible tools of tariffs. But tariffs, as discussed above, are different in kind, not degree, from other authority. Unlike those other authorities, tariffs operate directly on domestic importers to raise revenue from the Treasury. It sure does. Even though a tariff is in some sense less extreme than outright this is good for me. Yeah, the U.S. government owes me about $300. The U.S. government, you owe me about $300. I want my money. Give me my money. Even though tariffs is in some sense less extreme than outright competition, compulsory prohibition does not follow that tariffs lie on a spectrum between the poles. They're instead very clearly a branch of taxing power and fall outside the spectrum entirely. Finding no support in the statute the president invoked, the government turns to one that did not, the relevant law's predecessor. In 1975, the Court of Customs and Patent Appeal held the authority to regulate importation. In that law, authorized the president to impose a limited tariff. Am I that broke that I owe that $300? That's not the point. It's not the point that I'm broke and need $300. It's the point that if I owe the government $300, do you think they'd want their $300? Yeah, I think they do. They think they would. Is the U.S. government so broke it needs my $300? Yeah. So I think they should give me my $300 back. Fair is fair, ma'am. Finding no support in the statute the president invoked, the government turns out to one that did not, the relevant law's predecessor. In 1975, the court held that it did invoke the tariffs. When Congress enacted the relevant law 2 years later, the government contends it conveyed the same authority, except without, The EO about birthright citizenship? Yeah, I don't know about the birthright citizenship thing. That's a much more interesting question. And of course, oral arguments are coming up on April 1st. And I think I'm going to go to DC and watch them in person. I think that'll be fun. But the birthright citizenship question is more interesting. It's not that the president has authority in this domain, but he has the authority to enforce the Constitution. So if he's right, then, the Constitution gave him the authority. So, it's fair enough. Trump's going to speak about this at 12:45. I bet he is. The other country paid for it? I do not remember that. I do not remember the other country paid for it. I remember me paying for it. I remember me very distinctly paying for it. Am I watching the press conference? I wasn't planning on it. I guess we can if you want to. Let me know when it actually starts and maybe we'll tune in. The argument cannot bear the weight the government places on it. While this court sometimes assumes that Congress incorporates judicial definitions of legislation, we do so only when the term's meaning was well settled before the adoption. I can go to court for the $300? Maybe. I could file a claim. I could file a claim in the Court of Claims. Yeah, could do that. Yeah, baby, better have my money, don't you worry, city. Baby, I got your money. Yeah. A single express limitation from a specialized intermediate appellate court does not clear the hurdle. The tariff authority asserted by President Nixon, moreover, was far removed from the relevant authority's original purposes of sanctioning foreign belligerence. We are therefore skeptical that Congress enacted the relevant law with an eye towards granting that novel power. The government has another historical argument based on the court's wartime precedent. According to the government, those precedents acknowledge an inherent presidential power to impose tariffs during armed conflict. And the argument goes Congress in the relevant law and then this other law codify those precedents. But the argument fails at both steps. Insofar as the government relies on our wartime cases themselves, they are facially inopposite. Regardless of what they might mean for the president's inherent wartime authority, all agree the president has no inherent peacetime authority to impose tariffs. Nor are we persuaded that the dots connect from our wartime precedent through multiple iterations of the relevant laws should be interpreted to grant the president an expansive peacetime power. This argument relies extensively on a series of inferences drawn from scant legislative history. Such a attenuated chain cannot support, much less clearly support a reading of the relevant law that imposes distinct power to impose tariffs. Turning to this country's precedent, the government first relies on this statute or this case. There we held a section 232B. Thank you, Sandy, for the 10 gifts memberships, which allows the president to adjust the imports of particular goods to protect national security, includes the power to impose license fees. But that holding bears little on the meaning. I need to put on my glasses. My eyes are starting to really kill me. But that holding bears little on the meaning of the relevant law. As a textual matter, the section authorizes the president to not only adjust imports, but to take such actions as he deems necessary to adjust the imports of a good. The relevant law does not contain such sweeping discretion-conferring language. As for context, the relevant law states that no action shall be taken to decrease or eliminate an existing duty or other import restriction. Finally, the government invokes some other case, but that case offers no support. That relevant case was exceedingly narrow, did not address the power to regulate, and did not involve tariffs at all. If anything, that case highlights the importance of a close attention to this text. The terms of the law we hold do not authorize the suspension of the claims. So too here, the terms of the relevant law do not authorize tariffs. The president asserts the extraordinary power to unilaterally impose tariffs of unlimited amount, duration, and scope in light of breadth, history, and constitutional context of asserted authority. He must identify clear congressional authority to do it. The relevant law and grant of authority to regulate importation falls short. The relevant law contains no reference to tariffs or duties. The government points to no statute in which Congress uses the term regulate to authorize taxation. Until now, no president has read the relevant law to confer such power. We claim no special competence in matters of economics or foreign affairs. We claim only, as we must, the limited role assigned to us by Article 3 of the Constitution. Fulfilling that role, we hold that the relevant law does not impose tariffs. The judgment of the Court of Appeals is affirmed. The judgment of the District Court is vacated and remanded. Yep, all those things. All those things. All right, let's see what else we got today. Gorsuch concurring. The president claims that Congress delegated him extraordinary power to impose tariffs from any country it chooses and any amounts he selects. Applying the major question doctrine, the principle rejects that argument in full. I join in full. The Constitution lodges the nation's lawmaking powers in Congress alone, and the major question doctrine safeguards the assignment against executive encroachment. Under the doctrine's term, the president must identify clear statutory authority for the extraordinarily delegated power he claims. As the principal opinion explains, that's a standard he cannot meet. Whatever else might be said about Congress's work in the relevant law, it clearly did not surrender the president's sweeping tariff power he seeks to wield. Not everyone sees it that way. Past critics of the major question doctrine do not object to its application in this case, and they even join much of the principal opinion. But they insist they can reach the same result by employing only routine tools of statutory construction. Nice. Meanwhile, one colleague who joins the principal opinion in full suggests the major question doctrine is nothing more than a routine statutory interpretation. Well, I guess. I mean, I don't really know if it is or not. But either way, it doesn't really matter. Still others who have joined the major question doctrine in the past dissent from today's application of the doctrine. Kavanaugh joined by Thomas and Alito. Why am I not surprised? I'm a little surprised at Alito, I guess. Kavanaugh always likes to give the government more power. Thomas does some wacky things sometimes. I'm a little surprised at Alito. Finally, seeking to sidestep the major questions doctrine altogether, one colleague submits that Congress may hand the president most of its powers, including tariff power without limit. Is an interesting turn of events. Nice. Each camp warrants a visit. Start with the critics. In the past, they have criticized the major question doctrine for two reasons. The doctrine they've suggested is a novelty without basis in law. Whatever. And they've argued the doctrine is rooted in anti-administrative state stance that prevents Congress from employing executive agencies to do important work. Today, the critics proceed differently. They join a section of the critical principal opinion that applies the major question doctrine. And rather than a critique of the doctrine, they say only that it's unnecessary in this case because ordinary principles of statutory interpretation lead to the same result. Yeah, I don't know if maybe that's fair. Maybe that's fair. Maybe the major question doctrine is nothing more than routine statutory interpretation. I mean, I've never really thought about it, but sure, if you want to say that major question is just statutory interpretation and we just given it a new label for an old thing, I mean, okay, fair enough. All right, I understand that. Unpack that last claim first. My concurring colleagues contend that it's a major straight-up statutory construction. The relevant law does not grant the presidential power to impose tariffs. In doing so, they make a thoughtful point about statute text and context. Their approach today is difficult to square with how they've interpreted other statutes. Descending in past major question cases, they've argued that broad statutory language granting power should be read for all it's worth. Yet now when it comes to the relevant law, they take a more constrained approach. A little bit of inconsistency. Gorsuch is calling out his fellow colleagues for not being consistent. It's like, yeah, if you want to just say major questions is just a normal statutory tool and we didn't need to give it a new label, okay, fair enough. But if you're going to do that, you still have to apply whatever we're calling it. Like the label's not the thing, right? So if you want to give this new fun and exciting label, now we're going to call it the major questions doctrine. It's like, okay, but that's just a label. If you don't want to give that label, what difference does it make? It rose by any other names and so forth. But you're not applying it consistently regardless of what you call it. So that's the real problem. I'm there for it. Apparently my allergies are killing me today. Apparently that's the thing that's happening right now. My eye is about 5 seconds from rebelling against me. Considering some examples of how they proceeded in the past, two of my concurring colleagues confront a statute charging the OSHA with prompting safe and healthful working environments. They read that language as authorizing the agency to impose a vaccine mandate. In support of that reading, my colleagues stressed the statute's expansive language. Another provision authorizing the agency to issue... my eyes are... Help. And the scope of the agency was trying to address. Descending in Alabama versus Department of Health. Do I have eye drops? No, I've never been able to use eye drops successfully. I can't use them. My colleagues addressed the statute permitting the Center for Disease Control to issue regulation necessary to prevent the transmission of communicable diseases. As they saw it, the terms granted the agency the power to regulate landlord-tenant relations nationwide during COVID. In reaching these conclusion, my colleagues again highlight the statute's broad language suggests that it permits the agency to impose even greater restrictions than the one at issue in this case. Dissenting in West Virginia, my colleagues faced a statute allowing the EPA to ensure power plants employ the best systems of emission reduction. They read the provision as authorizing the agency to effectively close many power plants and transform the electrical industry from coast to coast. In support, they once more argued that statute's language was broad and expansive with no ifs, ands, or buts. They stressed, too, that the relevant statutory terms appeared in major legislation intended to address big problems. Statute authorized actions in the agency's traditional lane or wheelhouse. Finally, dissenting in Biden versus Nebraska, my colleagues took up a statute permitting the Secretary of Education to waive or modify any statutory or regulatory provisions applying to student loans during a national emergency. He is really calling out his colleagues, man, on the inconsistency, and I'm here for it. This in the language allowed the Secretary to cancel $430 billion in federal student loan debt because of COVID-19. Once again, they argued that the statutory terms were broad, expansive, capricious, and designed to afford the Secretary potent power to respond to national emergencies that were major in scope. Now compare all of that to how my colleagues proceed here. That case, they say, is nearly the opposite. While straight up statutory interpretation grant executive power all the power they sought in other cases, my colleagues insist this one's different because they simply do not give the president the power he wishes. That's a striking turn given the statutory terms before us. When the president declares a national emergency to deal with any unusual and extraordinary threat to national security, foreign policy, or economy, the relevant law permits him to regulate importation of any property in which a foreign country or national has any interest. Surely the authority granted here is broad and expansive. There's no ifs, ands, or buts either. I love it. I love Gorsuch. I love him so much. He's calling them out for their duplicity, and I am here for it. I am here for it in all these ways. Gorsuch is my boy. I like Gorsuch a lot. As a matter of ordinary meaning, the term regulate means fix, establish, or control, adjust by rule or method or establishment, direct by rule or restriction, or subject to government principles of law. And tariffs do just that. They fix rules that control, adjust, or govern imports of property in which any foreign country or national thereof has any interest. Without question, the relevant law is also a major legislation designed to address big problems and crises. By its term, the statute applies only during declared national emergencies involving threats to national security, foreign policy, or economy of the United States, and it tasks the president personally with responding to those emergencies, a responsibility surely more in his lane or wheelhouse than any executive official. Why do my concurring colleagues read the relevant law so much more narrowly than they have other broad statutory terms found in other major legislation addressing other emergencies? They say contextual clues justify a narrowing construction here. But what the concurrence calls context looks remarkably like a major questions doctrine rule that when the executive branch officials claim Congress has granted them an extraordinary power, they must identify a clear statutory authority for it. Take some examples. The concurrence points to unparalleled authority the president asserts to impose tariffs of any amount for any time only on the say-so. In other words, the president claims an extraordinary power. The concurrence observes that no president until now understood the relevant law to authorize imposing tariffs. In other words, the power is unheralded one. In other words, the power is unheralded. Along the way, the concurrence also adds a modicum of common sense about how Congress typically dedicates a consideration of whether Congress has ever before or likely would delegate the power to executive assets. In other words, statutory text must be read in light of the separation of power principles. Having borrowed all these concepts from major question doctrine, the concurrence then turns the key statutory terms before us regulate importation and observes to say nothing about imposing tariffs. And why is that fatal to the president's case? Because the president is attempting to exercise the core congressional power over taxes and tariffs, a power Article 1 the Constitution vests in Congress alone. And my colleagues all but apply the major questions doctrine today. Maybe they're simply recognizing what they have in other separation of power cases involving delegation of legislative power. The guidance is needed in greater when the executive branch seeks to take actions that will affect the entire national economy. Or maybe my colleagues believe the power the president asserts here outstrips even those powers executive officials asserted in past major question cases. But in the case, my colleagues' concurrence today suggests that the skeptics owe the major question doctrine a second look. Man, he is really just calling out his colleagues on being... He's just calling out his colleagues in every possible way, saying that they're just not... They're basically speaking out both sides of their mouth. And I am here for it. I'm here for it anyway. Now my eye is welded shut. And you can listen to press conference noises while we're waiting for the press conference to start. You can listen to press conference noises in the background. That'd be good. I'll just put it a little bit lower. All right, let's see where were we. 1 second, please. Okay. All of which leads to take up the challenge they posed in the past. Is doctrine really some sort of special canon that has only recently magically appeared? And is it really grounded in an anti-administrative state stance that prevents Congress from using its executive branch officials to perform important work? The major questions doctrine teaches that to sustain a claim that Congress has granted them extraordinary power, executive officials must identify clear authority. Far from a novel, much of the same principle is long applied to those who claim extraordinary delegated authority, whether in public or private law. Examples stretch and across many fields. Consider the common law of corporations. In early modern England, corporations could be formed only with an explicit ex ante and direct authorization. That authority can be given by the Crown, an act of Parliament, or in combination of the two. Some of the corporations exercise regulatory functions not unlike those performed by modern administrative agencies. Indeed, the initial settlements in Virginia and Massachusetts Bay, among others, were structured as corporations. English law treats these corporations having authority to issue bylaws, but that authority was subject to restrictions, one of which was that corporations could not regulate on major subjects without express authorization. That case involved a company of cutlers, a corporation for making knives and other cutlery. The company used that authority to adopt bylaws allowing individuals to enter the memberships, workers, and warehouses and search for deceitful and unworkmanly cutlery. What is deceitful and unworkmanly cutlery? What is that? What is deceitful cutlery? I have never met deceitful cutlery in my life. I am not sure. After the company ceased supposedly unworkmanly forks, the aggrieved owner challenged the company's actions in court, arguing that the bylaw under which it acted was a bad point of law because the power to incur forfeiture was not expressly given to the company by the Act of Parliament. Applying the clear statement rule, the King's Bench declared that the bylaw, and therefore seizure, unlawful. Lords Mansfield explained that the power of making bylaws was to incur forfeiture was extraordinary power over and above the default powers of corporations created by charter. For this reason, the power need to be expressly given by the company's progenitor, the Parliament. Since no such power had been clearly conferred, the seizures were unlawful. The same principles apply in American law. In re election of directors, a New York case court addressed a case involving 2,700 shares of stock in the Long Island Railroad Company. The company had declared forfeiture. All agreed the company had broad power to regulate shares. Still, the court called the forfeiture an extraordinary penalty and held that no such power had been expressly conferred upon the corporation by its charter. In fact, the court borrowed the clear statement rule from Norwell. If extraordinary authority is intended to be given, it must be by express words. The court in Ex parte Brunei proceeded similarly. The case involved the incorporated town of Cahaba, Alabama. The town set the price of liquor license at $1,000. What year? 1857? The town tried to make a liquor license $1,000 in 1857? Holy shit. Holy shit. Wow. Town set the price for $1,000. Fined James Burnett for failing to obtain one and eventually imprisoned him for not paying the fine. Burnett sought a writ of habeas corpus and argued that Cahaba had acted beyond the scope of the corporate authority. Without a clear statement rule, Burnett's argument would have stood little chance. That's because the town's charter granted authority to make and establish all such rules, bylaws, and ordinances respecting the streets, markets, buildings, and police of said town that shall appear to them requisite necessary for security, welfare, and convenience of the town, or for preserving health, peace, and order of a good government within the same. The charter even expressly gave the town the privilege of granting licenses for retailing of spirituous and other liquors. Semantically, the town's power was broad indeed and encompassed liquor licensing, but the court sided with Burnett anyway, reasoning that the town's exorbitant licensing fee had effectively banned the sale of liquor. The court held that Cahaba did not enjoy such extraordinary prohibitory power because it was not authorized by any grant of power in the charter. These cases are not outliers. Treatises confirm that the extraordinary power principle is fundamental to municipal corporations. A statute could not by implication invest in a body without extraordinary authority. Extraordinary powers require express words. I'm all about this. I'm all about this life. I'm all about major questions doctrine. I'm here for it. I believe in it, and I believe in it both ways because I'm a consistent person. I believe in it both ways. I believe that Congress should actually legislate. I know that's a bold hot take. Me and the founders have the same bold hot take. The legislature should actually be the one to legislate. I know, radical idea, radical revolutionary idea. In fact, legislatures should legislate. I am here for it. And if they want to give the president power, they should speak clearly. If they want to give them a lot of power, they should speak really clearly. So if they're just sort of vague and whatever, and then the president is allowed to interpret it any way he wants. If the president's just allowed to make these words sing and dance at his pleasure, well, then the president can kind of do anything, and that would render the legislature pointless. So we can't do that. We've got to have the legislature needs to legislate. And the president shouldn't be allowed to make any language do anything he wants at any time for any reason because president, That is not how any of this works. I am here for all this. I like all these things. This is all great.
More.
And any fair or reasonable doubt concerning the existence of power was resolved by the courts against the corporation of power was denied.
41.
The takeaway is simple enough. Early corporations often functioned like today's executive branch, exercising delegated regulatory authority. And when interpreting the scope of the authority, the common law had a clear statement rule that looked strikingly like the major question doctrine. Historically, a singular precept applied in agency law. As early American treatises put it, instruments conferring powers of attorney were ordinarily subject to a strict interpretation. A principal had a delegated broad power to an agent to act generally for him and in his name, including all things that should be done, requisite, expedient, and advisable to be done, as fair and concerns as he might be due if doing them personally. The agent then accepted certain debts on behalf of principal. The question for the court was whether this action was within the scope of the agency authority. The court said no. Powers of attorney are instruments to be construed strictly, and the power of attorney contained no express power to accept debts, so no such power had been given. Other examples abound. A power to sell a cask of whiskey did not include the unusual extraordinary power to offer a warranty against future seizures of casks, unless granted by express authority. Under a power of attorney, authority to enter contracts for a principal was subject to a strict interpretation, and generally did not authorize contracts of extraordinary character outside those connected with the principal's ordinary business. And a power to manage a mine did not authorize an agent to borrow money for the mine's operation on the principal's credit, because there was no express authority for such departure from the usual manner of running a mine. This was true even in cases of necessity, where a manager borrowed funds to address an emergency situation suddenly arising. Much of the same principle applied to executive officials. Often the legality of an executive action depended on the relationship between the size of the asserted power and the clarity of the underlying legal authority. As part of the investigation of seditious libel, the English Secretary of State claimed authority to issue warrant for the seizure of an author's paper. Lord Camden declared the seizure of unlawful, reasoning that the power asserted by the executive ought to be as clear as extensive. Or, as another report described Camden's decision, one should be naturally expected the law to warrant the exercise of power should be clearly in proportion to the powers is exorbitant. The seizure represented extraordinary power. Lord Camden found that no legal authority clearly authorized it. Accordingly, the warrant was unlawful and the seizure could not stand. Perhaps unsurprisingly, given this history, American courts applied the extraordinary power principle of Congress, and the states started delegating new regulatory powers to executive agencies. After the Civil War, governments worried about the increasing power of railroad companies responded by creating new agencies and imbuing them with broad regulatory authority. These bodies were among the first modern administrative agencies. And when they claimed extraordinary delegated power, both state and federal courts enforced the clear statement rule. The railroad commissions may have been the first, but they were not the last. Whenever executive officials claimed the power to criminally punish noncompliance with regulations, force employers to retain employees regardless of their unlawful conduct, or regulate interstate candy sales, this court has held them to much the same standard. Because their claimed power was so substantial, executive officials had to identify distinct authority for them. It is no mystery why the court proceeded that way when interpreting the legislative decisions to the executive branch. Article 1 of the Constitution vests all federal legislative power in the Congress, and Article 2 charges the executive branch with seeing that Congress's laws are faithfully executed. In a very real sense, then, when it comes to legislative power, Congress is the principal and executive officials are the agents. So what is the basis for the charge? The major question doctrine represents some magical innovation. Part of the answer may have to do with the fact that in the latter half of the 20th century, the court began experimenting with very different approaches. The court pushed aside the long-held skepticism of claims of extraordinary power and began affirmatively encouraging them. Chevron is just one example of this phenomenon. Yeah, any chance we get to shit on Chevron, I am here for it. I'm here for all the things when it comes to shitting on Chevron. Let's overrule it again, just for the hell of it. The case establishes a presumption, what nearly was the opposite of major question. Anytime they want to overrule Wickard v. Filburn would be fine, by the way. That would be the day. That would be the day. Someday they will overrule Wickard v. Filburn, and all will be right with the world. One hopes. That case established a presumption that was nearly opposite of major question doctrine. When Congress failed to speak clearly, courts put a thumb on the scale in favor of delegate power. Given that development, the long-standing principles animating the major question doctrine may have receded from view for a time. After all, the two doctrines often applied in the same place and counsels opposite result. But with Chevron gone, so is the conflict. Thank God. The court's application of major question doctrine is not an invention so much as a return to form. Now I turn to my concurring colleague's other charge, that the major question doctrine is premised on an anti-administrative state stance. It's important that they argue to allow Congress to delegate expansive powers. Members of Congress, unfortunately, this should be good, often don't know enough, and they know they don't know enough, to regulate sensibly on an issue. Nor can Congress easily anticipate changing circumstances. For that reason, members of Congress must rely on more adept and less constrained people found in agencies. Indeed, my colleagues say administrative decisions help to build the modern nation, and the major question doctrine they worry could jeopardize all that astonishing progress. The policy complaint, of course, is no reason to disregard a precedent or long-standing legal principles, but even taken on its own terms is a bit perplexing. The major questions doctrine is not anti-administrative state. It's pro-Congress. Preach it, baby. Preach it. Common law courts understood that few written instruments can anticipate every eventuality, and the principles sometimes draft broad delegation language to account for this. At the same time, courts appreciated the corresponding risk that delegees could easily exploit loose language in their commissions for their own benefit and to the detriment of the people they purport to serve. So common law courts often strictly construed delegated powers not because they were anti-delegee, but because they were pro-principle. The major question doctrine performs a similar function. Article 1 vests all federal legislative power in Congress, but like any written instrument, federal legislation cannot anticipate every eventuality, a point my concurring colleagues have observed in the past. And highly resourceful members of the executive branch have strong incentives to exploit any doubt that Congress's past work to assume the power for themselves. Very much that too. You know, the president will always try to increase his power. The major question doctrine helps to prevent that kind of exploitation. Our founders understood that they are men, not angels, and disregard that insight at our peril. Thank you for the 200 of you who are currently watching. As we wait for the stream, I'm going to take a break to allow my voice to give a break. But this has been pretty interesting stuff. Let's watch the nothing for a while. I'm loving Gorsuch's writing. I'm really loving him calling out his fellow colleagues, though. I'm there for it in a lot of ways. I bought a new keyboard. I actually bought 2 new keyboards. I'm testing. I had my old keyboard kind of got unusable. It's been, it's been a good keyboard, but it's been, a couple of years. It's been like 5 years or something. So I replaced it. I bought this thing from a company called Ducky. It's their 1.3 keyboard with cherry brown switches. My old keyboard also had brown switches, so I'm liking that a lot. And I also bought the Ducky 1X, which has inductive keys or something. And so I'm checking that out. Baba 4, yeah. I don't mind the slight clacky. Yeah, you get a little bit of clacky, but it's not that big a deal. So you guys get a little clacky. I don't know.
According to OpenAI, we do not stamp.
Kevin, how much time left?
Polls under review. Polls under review.
Got it. I'll go with that. All right. I'm glad AI can solve this.
Oh, okay. Okay.
There's only one of them.
There is only one, you're right.
How much time?
30 seconds.
In the game?
Yeah.
$27.99 Canadian from Dominique Fortin, 53.45. Here's almost 10% of the tariff for the watch. Appreciate it. While Trump might not allow the time, he's a foreigner. Here's a foreigner paying a U.S. tariff. There you go. Appreciate it. Thank you very, Dominique. Appreciate our friends from Canada. Anytime.
No.
I need water. Hold on. Let me get some water. Yeah, in terms of lapsing, the clock would start now because it was just ruled illegal now. So the clock would start today. You know, you can't obviously petition for refund of a legal tariff, but now it's really illegal. Yeah, that's when the clock starts. So, yeah. Am I going to read the dissent? I don't know. I might skim it. My voice is kind of giving out. Mary Steelman, 6534 for 1999 says, have some water money. Thank you. It was illegal when it was imposed? Well, yeah, but it was just determined to be illegal. That's not the same thing. I suppose it was illegal from the moment it was collected, but we just figured that out. So that's a change.
Please put your phone down.
You know, so that would start the clock. Because now I would have a claim. I didn't have a claim before, but now I do. Any tariff refund comes out of the American pockets. Well, the tariffs themselves came out of the American pockets. So it's just giving people their money back. Yeah, the tariffs come from the tariffs came out of the people's pockets in the first place. So just put it back. Just take the money that you took out of their pockets and just put the money back in their pocket. No problem. Just put it back.
Sorry, Landon, that's not good.
You didn't seem to have any problem taking it out of my pocket in the first place. Just put it back. Not all Americans who got a refund. All Americans who paid the tariff should. It was illegal, right? So put it back. Look, you took $300 out of my pocket. Just put it back. You took the money. Just put it back. The importers will pocket the money? Okay, maybe. Like a stem check? No, nothing like a stem check. It was money you took out of my pocket illegally. You're just returning my own money to me. It's nothing like a stem check. A stem check was money that wasn't mine in the first place. Stem check just came from ether. And you're giving money that, yeah, this is just give me my own money back. You took the money out of my pocket. Just literally put the money back. That's all I want you to do. I don't want extra money. I don't want bonus money. Just give me my money back. Write me a check.
Yeah, I'm here. Hello.
I'm talking about something I imported in this particular case, yes. I personally, individually, imported something, and I personally paid a tariff, and I personally want my money back. Give me my money back. You literally took it literally out of my personal pocket. Give me my money back. Yeah. Can they appeal? No. This is the end of the road. It's the Supreme Court. No, there's no appeal. That's the end of the appeals. You're the importer? Oh, that's easy. I have paperwork on that. Yeah, if I have paperwork, this is not a problem. Chicken sandwich. All right, let's read a few more words while we're waiting. They're running what, a half hour late so far? Unbelievable. Another feature of our separation of powers makes the major question doctrine especially salient. When a private agency oversteps, a principal may fix that problem prospectively by withdrawing the agent's authority. Under our Constitution, that remedy is not so simple. Once this court reads a doubtful statute as granting the executive branch again power, that power may be almost impossible for Congress to receive. Any president keen on his own authority, and again, what president isn't, will have a strong incentive to veto legislation aimed at returning the power to Congress. Perhaps Congress can use other tools, including its appropriation authority, to influence how a president exercises his new power. Maybe Congress can sometimes leverage these tools to induce the president to withhold a veto. But leveraging
Wow, that's a lot of people.
Oh, he's speaking. This
A
should be
new
good.
record. We set a record every time. Well, thank you very much for being here. The Supreme Court's ruling on tariffs is deeply disappointing. Certain members of the court absolutely ashamed for not having the courage to do what's right for our country. I'd like to thank and congratulate Justices Thomas, Alito, and Kavanaugh for their strength and wisdom and love of our country, which is right now very proud of those justices. When you read the dissenting opinions, there's no way that anyone can argue against them. There's no way.
I don't know about that, but
Foreign countries that have been ripping us off for years are ecstatic. They're so happy. And they're dancing in the streets, but they won't be dancing for long. That I can assure you. The Democrats on the court are thrilled, but they will automatically vote no. They're an automatic no, just like in Congress. They're an automatic no. They're against anything that makes America strong, healthy, and great again. They also are a, frankly, disgrace to our nation, those justices. They're an automatic no, no matter how good a case you have. It's a no. But you can't knock their loyalty. It's one thing you can do with some of our people. Others think they're being politically correct, which has happened before far too often with certain members of this court, and it's happened so often with this court. What a shame. Having to do with voting in particular, when in fact they're just being fools and lapdogs for the rhinos and the radical left Democrats, and not that this should have anything at all to do with it. They're very unpatriotic and disloyal to our Constitution. It's my opinion that the court has been swayed by foreign interests and a political movement that is far smaller than people would ever think. It's a small movement. I won by millions of votes. We won in a landslide. With all the cheating that went on, there was a lot of it, but we still won in a landslide. Too big to rig. But these people are obnoxious, ignorant, and loud. They're very loud, and I think certain justices are afraid of that. They don't want to do the right thing. They're afraid of it. This was an important case to me, more as a symbol of economic national security, and also, I would say, just for our country itself, so important, because we're doing so well as a country. We've never done so well. The good news is that there are methods, practices, statutes, and authorities, as recognized by the entire court in this terrible decision, and also as recognized by Congress, which they refer to, that are even stronger than the IEEPA tariffs available to me as President of the United States. And in actuality, I was very modest in my ask of other countries and businesses because I wanted to do, and it's very important, I wanted to be very well behaved because I wanted to do anything, I didn't want to do anything that would affect the decision of the court, because I understand the court. I understand how they're very easily swayed. I want to be a good boy. I have very effectively utilized tariffs over the past year to make America great again. Our stock market has just recently broken 50,000 on the Dow, and simultaneously, and even more amazingly, broken 7,000 on the S&P, two numbers that everybody thought upon our landslide election victory could not be attained. Think of that. Nobody thought it was possible to do it within 4 years, and we did it in 1 year. They said, you'll never be able, you'll go back and you read the geniuses, read their statements, all of the Nobel Prize winners.
What are we talking about now?
They said, no, you couldn't do it in 4 years. Well, we didn't do it in 4 years. We did it in 1 year. We broke every record in the book, and we're continuing to do so. Tariffs have likewise been used to end 5 of the 8 wars that I settled. I settled 8 wars, whether you like it or not, including India, Pakistan, big ones, nuclear, could have been nuclear. Prime Minister of Pakistan said yesterday at the great meeting that we had, the Peace Board, he said yesterday that President Trump could have saved 35 million lives by getting us to stop fighting. They were getting ready to do some bad things, but they've given us great national security, these tariffs have, and together with our strong borders, reduced fentanyl coming into our country by 30%. When I use them as a penalty against countries illegally sending this poison into our country to poison our youth, all of those tariffs remain. They all remain. I don't know if you know that or not. They all remain. We're still getting them, and we will after the decision. I guess there's nobody left to appeal to. But again, those 3 people, such respect. I've had a lot of respect for them anyway, but such great respect. But other alternatives will now be used to replace the ones that the court incorrectly rejected. We have alternatives,
Okay.
great alternatives. Could be more money. We'll take in more money, and we'll be a lot stronger for it. We're taking in hundreds of billions of dollars. We'll continue to do so. To show you how ridiculous the opinion is, however, the court said that I'm not allowed to charge even $1. I can't charge $1. Can't charge $1. I would have used 1 penny, but we don't make the pennies anymore. We save money. Can't charge $1 to any country under IEPA.
Correct.
Not $1.
Correct.
I assume to protect other countries. This must have been done to protect those other countries.
No,
Certainly not the United States
No,
of
it's not.
America,
No.
which they should be interested in protecting. That's what they're supposed to be protecting.
They're interested in protecting the
But I am
Constitution.
allowed to cut off any and all trade or business with that same country. In other words, I can destroy the trade. I can destroy the country. I'm even allowed to impose a foreign country destroying embargo. I can embargo. I can do anything I want, but I can't charge $1. Because that's not what it says.
It is what it says.
And that's not the way it even reads.
It is the way it reads.
I can do anything I want to do to them, but I can't charge any money. So I'm allowed to destroy the country, but I can't charge them a little fee. I could give them a little two-cent fee, but I cannot charge under any circumstances. I cannot charge them anything. Think of that. How ridiculous is that? I'm allowed to embargo them. I'm allowed to tell them you can't do business in the United States anymore. We want you out of here. But if I want to charge them $10, I can't do that. It's incorrect. Their decision's incorrect. But it doesn't matter because we have very powerful alternatives that have been approved by this decision. You know, they've been approved by the decision for those that thought they had us.
No, they haven't.
And they're saying that
No, they haven't been approved by
I
the
have the
decision.
absolute right to
I
license.
read it. No.
But not the right to charge a license fee. So think of that. I have the right to license, which is a very powerful word. In many ways, license is more powerful than tariffs. In fact, I was thinking about using it. But they came up with the idea that I can license, just like the people that were opposing me told them to do, but not the right to charge a license fee. Think of that. Who ever heard of such a thing? What license has ever been issued without the right to charge a fee? You get a license, you charge a fee. It's automatic, but not with this court. But now the court has given me the unquestioned right to ban all sorts of things from coming into our country, to destroy foreign countries. But a much more powerful right than many people ever thought we even had, but not the right to charge a fee. How crazy is that? Our country is the hottest country anywhere in the world right now. And it was a dead country 1.5 years ago under an incompetent president. But now I'm going to go in a different direction, probably the direction that I should have gone the first time, but I read the language. I'm very good at reading language, and it read our way 100%, but now I'll go the way I could have gone originally, which is even stronger than our original choice. As Justice Kavanaugh, whose stock has gone so up, you have to see, I'm so proud of him, wrote in his dissent, although I firmly disagree with the court's holding today, the decision might not substantially constrain a president's ability to order tariffs going forward. So, think of that. The decision might not substantially constrain. And it doesn't, he's right. In fact, I can charge much more than I was charging.
The court didn't give him any power.
So I'm going to just start.
It wasn't in the majority
I firmly
opinion.
dispedigree with the court's holding today.
The majority opinion didn't say
decision
anything
might
about
not
any other authorities. They
substantially
didn't analyze it.
constrain a president's ability to order tariffs going forward. That's because numerous other federal statutes, which is so true, authorize the president to impose tariffs and might justify most, if not all, of the tariffs issued in this case. Even more tariffs, actually. Those statutes include, think of that, those statutes include, for example, the Trade Expansion Act of 1962, Section 232. All of these things I know so well. The Trade Act
There are no more opinions
of
coming today.
1974, Sections 122, 201,
Yeah, there are no more
301,
opinions today.
and the Tariff Act of 1930, Section 338, all clear, but it's a little bit longer process. I thought I'd make things simple, but they didn't let us do that. I would like to thank Justice Kavanaugh for frankly, his genius and his great ability. Very proud of that appointment. In actuality, while I am sure that they did not mean to do so, the Supreme Court's decision today made a president's ability to both regulate trade and impose tariffs more powerful and more crystal clear rather than less. I don't think they meant that. I'm sure they didn't. It's terrible. And to think that the Democrats who oppose this only because they want to go the opposite way, they'd like to pack the court. They want to put on 21 people. They want to pack the court, pack the Supreme Court. Maybe they should do it. Maybe they would be better off if they did it. They want to pack the court.
We're in favor of packing the court now. That's nice. That's definitely going to work out well.
There will no longer be any doubt, and the income coming in and the protection of our companies and country will actually increase because of this decision. I don't think the court meant that, but it's the way it is. Based on long-standing law and hundreds of victories, and even, as I was pointed out before, even thousands of victories over the years, to the contrary, the Supreme Court did not overrule tariffs. They merely overruled a particular use of IEEPA tariffs. And essentially, it's the use to get a fee. I can do anything I want with IEEPA, anything. I just can't charge anybody for it. I can license, I just can't charge them. It's ridiculous, but it's okay because we have other ways, numerous other ways. The ability to block, embargo, restrict, license, or impose any other condition on a foreign country's ability to conduct trade with the United States under IEEPA has been fully confirmed by this decision.
No, it hasn't.
So now there's no doubt, because, you know, there were a lot of questions about tariffs because no president was smart enough to use them to protect our country from those countries and businesses that were ripping us off. You took a look at the deficits that we had with some of these countries. It was disgraceful what they got away with for many, many decades. But now we know, because this decision affirms all those things that some people weren't sure about. In order to protect, and it says so, in order to protect our country, a president can actually charge more tariffs than I was charging in the past.
That's not what the majority said. That's what Kavanaugh said.
Under the various tariffs.
The majority didn't
So
say
we
any of
can
these things.
Use other of the statutes, other
The
of the tariff
majority
authorities,
didn't give you any authority to do
which have
anything
also
under
been
any statute.
confirmed
They simply said you don't have authority to
are
do
fully
this under this
allowed.
statute. They didn't say anything about what
Therefore,
other things
effective
mean, or they didn't say
immediately,
any of those things.
all national security tariffs under Section 232 and existing Section 301 tariffs, they're existing, they're there, remain in place, fully in place, and in full force and effect. Today, I will sign an order to impose a 10% global tariff under Section 122, over and above our normal tariffs already being charged. And we're also initiating several Section 301
Here we go
and
again.
other investigations to protect our country from unfair trading practices of other countries and companies. Thank you for your attention to this
I still want my
matter,
money back
and
for the illicitly
I say
gained
quite
tariffs.
simply, which I've said for
I want my
a
money
long
back for the
time,
tariffs you charged me already
Make
under
America
illegal
great again.
authority.
And interestingly, we've already made it great, so I don't have to use that, but I don't think we'll ever give up on MAGA. MAGA is always going to be with us. If you have a few questions, you can let us know. But just to end, so we're going forward, we will be able to take in more money, and there'll no longer be doubt, because there was always doubt. I know the people that brought the lawsuit, and, you know, they're sleazebags, major sleazebags, but I know them, and they're foreign country centric. They were sending things into our country, and the people representing them knew full well, but they were sending things into our country, and they were beneficial to other countries, but very, very bad for us. And I stopped it, and we'll just keep it going. So we have more of a we have a totally firm decision now, and I don't
No,
think the
you
court
don't.
meant it, because the court doesn't show great spirit toward our country, in my opinion. A lot of bad decisions, but there are usually ways around it. This is something we could have done, as Justice Kavanaugh said, we could have done this originally, but we're doing it now, and the numbers could be far greater.
Yes, as Justice Kavanaugh said, being the key words of those sentences. We haven't gotten to his opinion, but Justice Kavanaugh Justice Kavanaugh wrote, well, no, I disagree with this, and also the president can kind of get there through other authorities. That's Justice Kavanaugh. Justice Kavanaugh thinks that. I'm not sure whether or not Justice Thomas joined him in that part. So maybe Justice Thomas also thinks that. That's not what the majority said. That's what one or maybe two members of the court said. The majority did not say anything. We read the opinion together. You don't have to take my word for it. We're reading, we're somewhere in the concurrence right now. But we read the majority opinion together, which is the opinion of the court. That is the law, the opinion of the court. The other things are musings. They're musing as to what one person thinks or doesn't think. Like that'd be me saying, like, look, Gorsuch, his opinion is law. No, it's not. It's him beating the shit out of the other members of the court, which is hilarious, but it's not law because it's not the opinion of the court. The only thing what is the majority opinion? So Kavanaugh thinks, okay, you can do this Trump's like, well, they've ruled completely that we've told. No, they didn't say any such thing. Kavanaugh had some musings. So you have Kavanaugh's vote apparently, but you already had his vote because he thinks this is legal. So that doesn't really get you anywhere. Kavanaugh thought this was legal. We saw how well that worked out. Kavanaugh thinks some other things are legal. What do other members of the court think? Have no idea. And we know for sure. No, you don't know any of these things. No, that's not how any of this works, man.
The hundreds of billions we've already taken in. Yeah, please.
Mr. President, I'm very curious. You've
I didn't
spoken
call
about
you in the red.
Thank you so much, Mr. President. Justice Thomas and Alito, as you know, are the most conservative constitutional justices. Do you think that you'll get to appoint 2 more justices later this term with similar ideologies? And what type of vetting process will they go through to ensure they uphold?
I don't know, but they're great
Constitution?
justices. That's all I can say. And I hope they're going to be around a long time. I hope they're going to stay healthy. They're great people. They're great. And Justice Alito, too.
And Thomas is probably going to retire this year. Alito might retire this year. Yeah, so we might have 2 resignations this year. It's very possible. It's very possible. Yeah, it could happen.
To add to the group, these are great men.
Right.
They're with a great love of our country and a great understanding of the law.
Mr. President, are you going to ask Congress to take additional action on tariffs now?
No, I don't need to. It's already.
Thomas, if he gets to appoint 2 more justices, man, right? It's like he'll have appointed a majority of the court, right? And this will be hilarious. Yeah, some presidents don't even get 1. This guy gets a majority of the court, man. That'll be good.
Been approved. I mean, I would ask Congress and probably get it. When people look at the real numbers,
Really, you think you'd get this out of Congress? Really, if you think if you think that would just be really easy. I mean, this is a way easier approach, Donald. If you really believe that if you ask Congress, they just give it to you, then just ask Congress. I mean, the Supreme Court will be perfectly happy with that. I promise you. If you go to Congress and be like, can I have all this wonderful authority? And Congress writes you some really clear language, Supreme Court's not going to have anything to say about that. So that would be way easier. Just go to Congress and get them to do it. It'll be super simple, barely an inconvenience. Let me know how that goes for you.
and you look at hundreds of billions of dollars that have come into our country. Yesterday, I was at a steel plant, as you know, and I went to great place, great plant, great, wonderful people. And they were telling me, I said to them, you were there, a lot of the press in this room. Of course, I don't think this plane's big enough to take the press in this room, but a lot of the press right here. We're in Georgia. And I said to the owner, I made a speech at a factory. They make steel products. And I said, how are you? Nice to meet you. How's business? President, I'd love to kiss you. This is a very powerful man. I don't want to be kissed by that man. But a very powerful, strong man. He's been in the steel.
What?
Business for many years. His father started it. And he said, sir, I want to kiss you. I said, why? He said, because we were down to working 1 hour a week, and then you came in and imposed tariffs, and all of that foreign junk that they were dropping into our country stopped. And we're now going to double shifts, 7 days a week, and we may be very soon going to 24 hours around the clock, almost 7 days a week. He said, sir, I want to kiss you so badly. And I said, no, thank you. But you know what? He just to finalize it, he said, oh, this is a great place in Georgia. He said, all up and down the highway, same exact answer, sir. We're all going out of business. We're going to go bankrupt. We're all going out of business. And now every one of us are thriving, and we're hiring people like we haven't. He said, like I've never, and he's been in business for, I think, 45 years, like we've never hired before. That's because of tariffs. And we're going to keep it going the same way. And you're going to start to see the results in a year from now when all those factories start that are under construction right now. You see all the construction numbers are so good. Those construction workers are building factories that are going to be open, including not only AI, which is big, but car plants coming in from Canada, who ripped us off for 30% of our market. Mexico ripped us off for a big portion. Over the years, they've taken our market. They've taken our cars. They manufacture them in Japan, Germany, and all over the place because nobody's standing in this position. The position I have as President of the United States had the insight, the courage, well, I don't know what it is, to charge tariffs. You can make your product outside. You can put our people out of business. You can put everybody on the unemployment rolls. But if you're going to make a car in some other country, you're going to pay a 15, 20, 30% tariff. And those things would have never happened. We wouldn't have lost our business. Same thing with, as an example, Taiwan. Taiwan came in. They stole our chip business. They make chips. For 30 years longer,
How did they
made
steal your chip
and,
business?
They put our companies, Intel would be now the largest company. I saved Intel. I literally saved it at the beginning of this administration.
Uh-huh.
And now all those companies in Taiwan are building factories in Arizona, Texas, and various other places because they don't want to pay tariffs. They're all pouring into the United States. But just like that great patriot said yesterday, sir, what you've done, nobody thought was possible. And Steve Moore, a highly respected economist, came into my office yesterday. He said, you've done something nobody's ever done. 22 Nobel Prize winners in economics said we would right now be in a recession. And you said, no, we're going to have a booming country. We're going to have a booming country. You were right. All 22 were wrong, and you were right. This country is booming, and it's booming because of the election on November 5th, and it's booming for another reason. It's booming because of tariffs. Yeah, please, go ahead.
Thank you, Mr. President.
You said ahead of this decision that if the Supreme
Yeah,
Court
please,
ruled-
go ahead.
Thank you, Mr. President. What will you say to foreign nations who seek to renegotiate their deals? And what did you mean a moment ago when you said that the Supreme Court has been swayed by foreign interests?
Well, I think that foreign interests are represented by people that I believe have undue influence. They have a lot of influence over the Supreme Court, whether it's through fear or respect or friendships, I don't know. But I know some of the people that were involved on the other side, and I don't like them. I think they're real slime balls. And got to do what's right for the country. You got to do what's right for the Constitution. That's why I respect so much Justice Thomas and Alito, Kavanaugh, because they not only dissented, their dissent is so strong. When you read their dissent, you know, a lot of times you'll read a dissent and it's like, well, you don't know, it could go either way. There's no other way. The good news is it's...
Oh, no, I found the majority opinion pretty persuasive to my mind. I don't know if I'll read it verbatim because my voice is trying to give out, but we'll skim it. We'll skim the dissent and see if it makes a better case. I found the majority pretty compelling, but, you know, we'll give it a shot. We'll see.
It's like Justice Kavanaugh said, very strongly said, you have other ways you can go. You don't have to go that way. You can go other way. There are numerous other ways you can go. And frankly, this should have been done by presidents many years ago. They allowed our country to be eaten alive. We lost 50% of our car business. We used to make cars. We made all the cars. And then Mexico came, Canada came, and Japan and Germany. But they're all coming back now. They're all coming back at record levels. No, please. I'm not talking about.
What's the Tariff Act, 1930? Don't know.
It's fake news.
I'm not familiar with it, but thanks for the
You
question.
made the case that the economy is the hottest it's been in a long time. January jobs report beat expectations, CPI report beat expectation, real wages are up. What would you tell Americans who are worried that this decision will kind of throw the economy that you have projected going in the right direction at a very rapid pace off track?
Well, thank you for the question. And I will say this, we really are at a very important point. I've been waiting for this decision so long. They could have made this decision a long time ago.
Not really.
Not complex. They're wrong on it. It's a ridiculous decision. But they should have released this a long time ago. We waited months. And that gave uncertainty. Now we have certainty.
No, you don't.
And I think you're going to see the country get much stronger because of it. Look, we were ripped off by almost every country in the world. If you look at the surpluses, almost every country in the world that did business with.
You know, I don't know for sure, obviously, because I don't know what the majority thinks about other things. But, you know, if I had to bet, I think your odds are better that there's an injunction and probably a very rapid assent to the Supreme Court, and they probably keep the stay in place. So whatever he's going to sign today is going to be challenged immediately. There's going to be a stay immediately. It's going to be taken to the Supreme Court immediately. And my money is the Supreme Court says the stay stays in place while they're figuring it out. So yeah, that's what I think is more likely to happen. If I had to bet, we'll see.
With us, our people were stupid. And I blame presidents for it because they're ultimately the leader. We were being ripped off by almost every single country in the world had some massive surpluses. China had hundreds of billions of dollars in surpluses with the United States. They rebuilt China. They rebuilt the army. We built China's army by allowing that to happen. I have a great relationship with President Xi, but he respects our country now. Now, what we've done, I charged China a 20% tariff as a penalty for sending fentanyl in. And that was 20 times more than they could make by selling fentanyl. And I said, you know, at some point you're going to say, like, and they have reduced it. You know, fentanyl is down by more than 30% coming into our country. Part of that is a strong border. We have a strong border now. But thank you. Thank you for your question.
Mr. President, sir, you warned once in a social media post that if the Supreme Court did this, shot down your tariffs, the U.S. would be, quote, financially defenseless. Are we financially defenseless right now?
No, because we're doing something in a different way. We're doing something in a very powerful way. And we're using things that some people thought we should have used in the first place. But it's more complicated. It's a little more complicated. The process takes a little more time. But the end result is going to get us more money. And I think it's going to be great. Yeah, please. Peter, go ahead.
Thank you, President Trump. So, since Liberation Day, there's about $175 billion in tariff revenue that is now in limbo. Do you have to refund $175 billion?
Think of it, Peter. Very fair question. They take months and months to write an opinion.
Give me my money back.
And they don't even discuss that point. We've taken in hundreds of billions of dollars, not millions, hundreds of billions of dollars. And so I said, well, what happens to all the money that we took in? It wasn't discussed. Wouldn't you think they would have put one sentence in there saying that keep the money or don't keep the money, right? I guess it has to get litigated for the next 2 years. So they write this terrible, defective decision, totally defective. It's almost like not written by smart people. And what they do, they don't even talk about that. Your question is very basic. That was the first question I asked also to make you feel good. They said, what about all the money that we've taken in? Sir, they don't discuss that. How crazy is that?
Yeah, they send it back down because the Supreme Court doesn't typically do that. The Supreme Court typically doesn't do that. They try to only answer the question and then they send things back down. That's their typical pattern. So that's how the Supreme Court normally rolls. Yeah, they send it back down for further things consistent with the opinion. So one of the first things the lower court's going to be asked is about this issue, and they'll deal with it. That's how the Supreme Court normally rolls. I guess Donald Trump doesn't read a lot of Supreme Court opinions in his time. Probably doesn't spend a lot of time reading Supreme Court opinions. So, but yeah, that's the Supreme Court. they tend to answer things narrowly, somewhat frustratingly so to me. Every once in a while they'll stretch, but most of the time they're pretty narrow. It can be a little frustrating sometimes, but that's how it rolls. So what do you want? That's just the way it goes.
You don't plan to honor refunds for companies that file for them?
I just told you the answer, right? I told you the answer. It's not discussed. We'll end up being in court for the next 5 years. Go ahead, Green.
Thank you, Mr. President. When you are talking about the relationship with countries that you have sought trade deals with, do you anticipate that they will seek to renegotiate those? What do you say to them, and do you view this as a potential undermining power for your
We're
negotiations?
going straight ahead with 10% straight across the board, which was the absolute right to do. And that's taking place. That's a lot of money coming into our country. And then during that period of about 5 months, we are doing the various investigations necessary to put fair tariffs or tariffs, period, on other countries. So we're doing that period, but we're immediately instituting the 10% provision, which we're allowed to do. And in the end, I think we'll take in more money than we've taken in before.
Mr. President, you've used the tariff revenue to pay for a host of federal policies. You've claimed that they will pay for them. What happens
Well,
to
like the farmers, we took care of farmers. You know, the farmers were mistreated by foreign countries very badly, very, very badly. And last week I gave them $12 billion out of tariff money. We intend to, out of tariff money, because just so you understand, we have tariffs. We just have them in a different way. And now they've been confirmed by the Supreme Court of the United States.
They did no such thing.
So there's no longer that question out
Yes,
there
there
about
is.
tariffs. And we'll be taking in hundreds of billions of dollars. And countries that have treated us badly will have to pay a price for treating us badly. And countries that have been good to us will be treated very well. We just left the top person in a place called Vietnam, just left my office. Great gentleman, strong and smart. He said, you know, I think this means you're allowed to charge us more tariffs than before. And Canada said to Jameson, I might want to say it, Jameson, but Canada said, I hope you win this decision, because if you don't win, you'll actually be allowed to charge us, with a little additional work, higher tariffs. Jameson,
Does anyone believe Canada said anything even remotely close to that? Yeah, me neither.
you want to comment on that?
Yes, sir. So, to the President's point, we have a lot of tools out there. We have Section 122, which will be implemented today. It will be signed today and implemented very shortly. We have Section 301 investigations, which are incredibly legally durable, where we can investigate and address unfair trading practices that have led to our huge trade deficit. And so you can look forward in the coming days.
And you know,
weeks
I think it's worth noting, by the way, here that I'm not trying to adjudicate like the underlying issue about the trade practices being fair or unfair, right? This is where I think, you know, because I'm just trying to answer the straight legal question. But I'll say this just for the sake of clarity, for whatever it's worth. You know, I'm not trying to say that our trade practices are or are not fair, or we are or are not being exploited. And I'm not trying to answer any of those questions. Right? I mean, there's a lot of different ways to look at these things, and you know, a reasonable person could look at the situation and feel like the United States policies are not fair to the United States. I think that's a reasonable thing to think, and they could even think they're grossly unfair to the United States. So I'm not here to try to answer that question. I'm just simply here to answer legal questions. It's what I do with my time. Right? So is the United States being exploited? You know, I don't know, but assuming that it is, can we fix it this way? Not so much, no, but maybe another way. And the Supreme Court did not answer that question. He keeps saying it. Maybe he's wish casting. He's wishing if he says it hard enough, it'll become true. And maybe it's true, but we don't know because the majority didn't say. Kavanaugh thinks something. Kavanaugh could be right. Kavanaugh's a smart guy. Kavanaugh could be right. He's a smart guy, and maybe the other members of the court agree with him. Who can say? On balance, I think probably not, but, you know, it could be. But, you know, not so much. You know? So, yeah.
Come out, and we're going to keep continuity in the program. And we're going to keep addressing this so that the deficit can keep going down. That's the trend it has, and we can make America great again.
No.
I am pretty confident, though, that roughly tomorrow, someone is going to file an injunction against the new and exciting thing that he's signing today. I'm pretty sure someone's filing that tomorrow, if not late tonight. You know, they are currently drafting it, and they might have it already drafted, to be honest, because this is foreseeable, right? So some lawyer somewhere might already have the motion for the injunction sitting in a drawer, because they're just waiting to fill in the parts they need to fill in. You know, who knows? But someone is filing today or tomorrow. The court is going to issue an injunction. If I had to bet, they're going to kick it up to SCOTUS. And if I were a betting man, SCOTUS is going to uphold that injunction because they don't like being fucked with. So they're going to uphold the injunction, and then they're going to slow everything the fuck down. That's what I would do if I was the Supreme Court. I'd take this, put a stay on the injunction, and then I'm just going to slow everything the fuck down, so I don't have to deal with it for a while. That sounds like a good plan. I'm in for it. Yeah, it sounds roughly about right.
Several of Republicans in Congress have supported this decision by the Supreme Court, and Hakeem Jeffries, the Democratic leader, has called you a wannabe king. Why wouldn't
him a low IQ?
But why wouldn't
he doesn't even know? And I watched him the other day interview. The guy doesn't even know what a tariff is.
But there's been bipartisan criticism.
No,
I'm pretty sure he knows what a tariff is.
There's several Republicans have said that.
Yeah,
But why wouldn't you just work with Congress to come up with a plan?
I don't have to
push tariffs.
I have
through?
the right to do tariffs, and I've always had the right to do tariffs.
No,
and
you
it's all
don't.
been approved by Congress.
No, you
so
don't.
There's no reason to do it. All we're doing is we're going through a little bit more complicated process. Not complicated very much, but a little more complicated than what we had. We'll be able to take in tariffs, more tariffs. And the Congress people and the Congress,
the Canadian tariffs last week.
Yeah,
There's been votes in the Senate against it.
Yeah, because we lost 2 Republicans or 3 Republicans because they're not good Republicans. What you don't say, you don't say that we got 215 votes.
You need 218 for something to pass.
Yeah, sure we do. We might have lost 3 votes, and we got. And what was the score on the Republican side? 215 to 3, right? But you don't say that. We have great unity. There's great unity in the Republican Party, and I hope everyone's going to vote Republican, because otherwise you won't have a country left, because these people have been destroying. They are destroying our country. Please.
Mr. President, the 122 tariffs, that 10%, is that going to be for 150 days, or do you want to charge that indefinitely?
We have a right to do pretty much what we want to do, but we're going to charge it starting effectively. I think it's 3 days from now. Yeah, please.
Mr. President, you speak to a lot of factory workers, a lot of manufacturing workers. What does the Supreme Court ruling say? What's that message to those factory workers?
Well, I think the factory workers are happy because we're now telling them that they're going to look. The man I met with yesterday, who owned a factory, was out of business. He was out of business, and now he's employing.
I'm pretty sure that that's not possible. He owned a factory, but he's out of business. Which one is it?
5 times. In fact, I walked in. He's got a brand new crane. I said, "How old is that crane?"
He's got a brand new crane, and he's out of business. That's exciting.
The Great Big Beautiful Act gave no tax on tips, no tax on Social Security, no tax on overtime. He said this great, big, beautiful bill, frankly, has been the best thing that's ever happened for the workers much more so than for rich people. The only thing it does for rich people, it allows them to hire a lot more people. But when I saw him, and then he said, it's all up and down the line. This is a place in Georgia, all up and down, other factories doing different, not only steel products, different. He said, every one of us was out of business. We could barely make it.
Were you out of business, or could you barely make it?
1 hour a week. Think of it. 1 hour a week to make just a few little trinkets or whatever they make.
Well, you were out of business, but you were working.
Now they're going round
you were
the
working
clock.
a few hours a week to make
month ago,
trinkets.
I went to Michigan, went to Ford, and I met with Bill Ford, the head of Ford, and we were in one of the biggest plants, an original plant from the early 1900s. Where, by the way, I might add this, it's not really relevant, but it's all relevant. Murders are down the lowest since 1900, around the time that he had this plant. That's 125 years. We have the lowest murder rate. Okay. And our crime is way down in the country. The factories that we're talking about, the people that we're talking about, they are so thrilled with Trump. So whether we charge IEEPA tariffs or whether we charge tariffs under a different section, that's what we're going to be doing. There's no way we can lever. This is what happened to our country. This is why we owe $38 trillion, which we'll get rid of in pretty good course. We have a very incompetent Fed chairman who likes high interest rates. For political reasons, he likes them. But we're going to have somebody very good. Interest rates should come down very substantially. I think we should pay the lowest interest rates on the planet. There should be no country, and we don't do that. We're number 38. This is just bad policy for a long period of time. But what's happened is we've made America strong again. We've made America great again. We should pay. As an example, the country of Switzerland, we were getting almost no tariffs from them. We had a $40 billion deficit. And the prime minister called me up. She said, but we are a small country, because I said we're going to raise it to 39% from nothing. That would have rendered them not very successful. As opposed,
I still rather have Trump than Kamala every day of the week. So you may not like Trump, but if the alternative is Kamala Harris,
So right now they're considered elite. But if we put a tariff, they would, and I realized then, she said, but sir, we are a small country. I said, you're a small country with a big deficit. For us, you're making a lot of money off the United States. If we do that, a lot of these elite countries, they're elite because we let them make so much money. And I want them to do well. But I don't want them to do well on the backs of the American taxpayer. So I appreciate your question. I think it's reasonable.
President Trump, you said that you were disappointed with that, but were you surprised with this decision? What you felt when you...
I was surprised because I thought that what we did was, number one, according to, I mean, I read the paragraphs. I read very well. Great comprehension.
I'm not sure about that. I have to be honest.
Everything there is to read, and I said, we can't lose this case. But we can when judges are political, when they want to be politically correct, when they're catering to a group of people in D.C. Maybe I don't know what it is, because when you read it, there's no other interpretation. There is no other interpretation.
Oh no, I thought the majority was pretty good, to be honest,
because what
Mr. Trump.
has come out, and I'll say it for the third time and maybe the last time in a while, is that we've taken the uncertainty of tariffs out, because we had uncertainty. We got sued by sleazebags, I know them well, that are very outside country, China-centric, but outside country-centric. And they're going to end up not doing as well as they did before. America was becoming really, really, we're strong again. Hey, we have the strongest military. I rebuilt the military in the first term. We have the most powerful military. We make the best equipment. And even them, you know, we could do much better. We have people that get paid a lot of money to manufacture Patriot missiles and javelins and all the different things. But when you want them, they're too slow. And we put them on notice, and they're going to make, our country is building a lot of things right now, and our country is doing really well. And we're going to keep it that way. The bottom line is that the word certainty is now in the equation. Every single thing I said today is guaranteed certainty. It's been tested, as Jameson said 1,000 times. Literally, I said hundreds of times. He said, sir, actually thousands of times, and won in all of the courts. And we're just going back to that. And the problem is that we had other presidents that weren't into trade. Maybe they weren't business oriented. Maybe they weren't smart. We had some dummies too, you know. I respectfully say we had some real dummies. So we are going to keep it going just as before, probably more so. But you're no longer going to be asked, every time I got up, you'd ask, well, what happens if you can't charge tariffs? Now we can. And by the way, in their decision, they specifically said we can do these.
No, they did not.
Alternatives. Yeah.
Read it again.
David, on the trade deals that were negotiated using IEEPA tariffs, do those stand now, or are they have to be redone?
Well, some of them stand. Many of them stand. Some of them won't, and they'll be replaced with the other tariffs.
Mr. President, on the Supreme Court justices who ruled against this the policy, striking it down, are they still invited to your State of the Union next week? And will you speak with them?
They are invited, barely. Barely. 3 are happily invited. No, they're barely invited. Honestly, I couldn't care less if they come, okay? Go ahead.
Thank you, Mr. President. On the trade deal, which is the framework which is to be signed with India sometime soon, will that stand now? And on the decision,
changes.
Nothing changes?
No, nothing changes. They'll be paying tariffs, and we will not be paying tariffs. Our deal with India is they pay tariffs. This is a reversal from what it used to be, as you know. India, and I think Prime Minister Modi is a great gentleman, a great man, actually, but he was much smarter than the people that he was against in terms of the United States. He was ripping us off in India. So we made a deal with India, and it's a fair deal now, and we are not paying tariffs to them, and they are paying tariffs. We did a little flip.
Markets are up as of now for this.
Mr. President.
No, the India deal is on here.
Mr. President.
Thank you so much, Mr. President.
All the deals are on. We're just going to do it a different way.
Mr. President.
Thank you so much, Mr. President. I think there's another war that you stopped and you should take the credit, which is in Syria. Secretary Rubio, after his meeting in Munich with the Syrian Foreign Minister and the Kurdish General Muslim Abdi, he said that President Trump was directly involved in efforts to stop the fighting between the Kurds and the Syrians. How will your administration will make sure that this peace is sustained? And do you support the idea
Well,
of...
it's a very different topic, and so I don't want to spend a lot of time, but all I can say is that the president of Syria, who I essentially put there, is doing a phenomenal job. He's a rough guy. He's not a choir boy. A choir boy couldn't do it. But Syria is coming together, really coming together well. And thus far, he's been very good to the Kurds. Yeah.
Thank you, sir.
Mr. President, what's your message to the Iranian people after 2 rounds of talks with them? Do you have any message to the Iranian people?
The Iranian people in Iran or people here?
People in Iran.
They better negotiate a fair deal. You know, the people of Iran are a lot different than the leaders of Iran. And it's very, very sad situation. But 32,000 people were killed over a relatively short period of time. They were going to hang 800, 2 weeks ago, hang, some by crane. They lift them up with a tall crane, and they play them around the square. They were going to hang 837 people. And I gave them the word, if you hang one person, even one person, that you're going to be hit right then and there. I wasn't waiting 2 weeks and negotiating. And they gave up the hanging. They didn't hang 837. Supposedly, they didn't hang anybody. But no, I feel very badly for the people of Iran. They've lived in hell. Please.
Thank you, sir. Mr. President, you mentioned multiple times foreign influence over the Supreme Court. Do you have evidence of that? And if not, will you investigate that?
You're going to find out.
What alternatives are you going to put into place in your relationship with Europe, and also those tariffs that has been called illegal? How they're going to go impact the relationship with Russia, that you sanction
Well,
some
I want
countries?
Europe to strengthen up. Europe has gone woke. Europe is not recognizable when you go into so many places. Not all countries. You look at Hungary. You look at Poland, Czech, Slovakia. There are some countries that have gone very much the opposite. Some really, and some others. But Europe has to be strong, and they become soft and not recognizable. You go into some of the countries, I don't want to be specific, but I think everyone knows what I'm talking about, and they're not recognizable. They become, the environmentalists have taken over. They've got windmills destroying their fields and their beautiful meadows and their oceans, and they're paying a fortune. Now, Europe has to get smart. Europe's getting killed on two things, energy and immigration. And if they don't solve both of them fast, Europe is not the same place. Yeah, please.
Mr. President, Justices Gorsuch and Barrett, are you surprised in particular by their decision today? And do you regret nominating them?
I don't want to say whether or not I regret. I think their decision was terrible. Yeah. I think it's an embarrassment to their families. You want to know the truth? The two of them.
Nice.
Yeah.
Specifically on that
Say it again,
$2,000
please.
tariff check.
Mr. President.
I didn't call you.
You didn't call me?
Yeah, Mr. President, to be clear, do you believe at the end of implementing these new tariff tools, the tariff rate and tariffs will ultimately be higher than they currently are?
Potentially higher.
How much higher?
It depends, whatever we want them to be. But we want them to be fair for other countries. And, you know,
I don't think I'm going to get nominated by Trump to anything in the near future, though, because yeah, I have the wrong thing. Yeah, I mean, I'll read, at least skim. I'll skim Kavanaugh's dissent. I don't know that I can read it word for word. You have to give my voice a break, but we'll skim it together and see if it makes a persuasive case. I thought the majority was pretty good, but maybe Kavanaugh has something to say. But yeah, I don't know if I'm the right jurist for him. I don't know, man. I'm not getting that nomination, am I? Damn it.
Some countries that have treated us really badly for years, and it's going to be high for them. And we have other countries that have been very good, and it's going to be very reasonable for them.
So specifically on the tariffs question, I mean on the $2,000.
I didn't call you.
Mr. President, thank you, Mr. President. Do you have any plans to travel to India for the Quad Summit, and how do you think your relationship with India is right now?
I think my relationship with India is fantastic, and we're doing trade with India. India pulled out of Russia. You know, India was getting its oil from Russia, right? And they pull way back at my request because we want to settle that horrible war where 25,000 people are dying every month. And my relationship with Prime Minister Modi is, I would say, great. I also stopped a war between India and Pakistan, as you know. There were 10 planes we shot down. That war was going and probably going nuclear. And just yesterday, the Prime Minister of Pakistan said President Trump saved 35 million lives by getting them to stop. That's and I did it largely with tariffs. I said, look, you're going to fight, that's fine, but you're not going to do business with the United States, and you're going to pay a 200% tariff, each country. And they called up and they said, we have made peace. Okay? I just want to thank you all. Look, great certainty has been brought back to the economy of the United States and actually the economy of the world, because we generate so much in the world. We're the biggest in the world, and we're now the strongest by far. We were a country that was dead 1.5 years ago. Now we have the hottest country in the world. We're going to keep it that way. Thank you very much, everybody. Thank you. Thank you very much.
Thank you, Mr. President.
Did you say 32,000 were killed in Iran, sir?
Okay, that was definitely a conference of some variety. That was interesting. All right, so let's skip the rest of Gorsuch's concurrence, because I assume it's just going to be more of the same where he just beats up on everyone. Let's read some of the dissent. Okay, Barrett concurs. All right, what do we got here? Kagan concurs. We don't need a concurrence. We're looking for the dissent. Jackson concurs. Thomas dissents. Where's Kavanaugh? Oh, okay. Guess Thomas comes first. So he talks about non-delegation doctrine, legislative vetting clause, legislative power, talking non-delegation. He says Congress can delegate it. Okay. There's some things they can't delegate. Okay. Then he's still talking about whether or not it can be delegated in principle. Still talking about whether or not it can be delegated in principle. He spends all his opinion talking about whether or not it can be delegated in principle, but he doesn't actually seem to discuss whether or not this is a delegation. So Thomas's dissent is about whether or not it can be delegated in principle, which I don't really have an opinion on at this time. And he just goes to regulating and importing and then say this is imposing duties, which is not the same thing. But he just kind of assumes the very thing that he's trying to establish, it seems to me. So Thomas's dissent doesn't seem to go anywhere. Thomas's dissent doesn't seem to go anywhere. So that doesn't go anywhere. Let's look at Kavanaugh. Common tool since early U.S. history, post tariffs, authority, blah, blah, blah. Regulate importation. So he thinks that regulate does include the authority. Permit 10% tariffs on foreign products. He led the tariffs on the predecessor statute. Yeah, well, I can't speak to what was true in the predecessor statute, so because that's not the issue today. And they were upheld under the predecessor statute. Okay. Adjust the imports. Relevant statutes do not refer specifically to duties or dairies, but more broadly to regulate importation or adjust imports. Okay. Blah, blah, blah. The plaintiffs of the court acknowledges they authorize quotas and embargoes. Well, they didn't actually say what that means. The majority opinion. Employ the lesser power tariffs. We can just import a parent. Yeah, the president could block all tariffs, but cannot block even $1. Yep, that's basically true. This approach doesn't make sense. Well, maybe, but that's what it seems to say. This concludes otherwise. 6 majority, 3 lean on major questions. Doctrine, my view of the major question can is not control here for 2 historical opinions. Clear authority, regulate unheard of power. Has never applied the major question doctrine in the foreign affairs context. It should apply in every single context. So this is not persuasive to me. Yeah, I don't buy that at all. Strain of present or in going forward, that's because numerous federal statute. I'm not here to adjudicate other statutes at this time. Interim effects could be substantial. Text in history, echoed. Rhetoric is a red herring. Important principles here. Internal authorization powers tariffs. Uh-huh. Blah, blah, blah. Okay, Clay, yes. statutory reference historically been still common means to regulate transport. Regulate phrase been young to encompass tariffs. Blah, blah, blah. So he's doing a historical analysis relative to the text, how the law came to be. I mean, he has some ideas in here. He's going through a lot of history here and various things that various presidents have done. Kavanaugh seems to have some points on history and tradition and how predecessor statutes were written. So I think to really give Kavanaugh his due, I'd have to give it more than a drive-by. So to really give Kavanaugh his due, I'd have to give it more than a drive-by. He seems to have some analysis here that rests on the history of various predecessor statutes and what various presidents have done, and also predecessor decisions of the Supreme Court. So to really give Kavanaugh his due, I'd have to really dig into it and really think about it. So I can't really do that right now, just because, it require a lot of time and focus to really pick it apart. But he does seem to have some merits to it. But so maybe. Yeah, Nixon and Ford weren't exactly able to use them unopposed. They were challenged. It was just found to be legal. But that's under predecessor statutes with predecessor language, and maybe there's a difference and maybe not. What is a tariff? A tariff is an import tax. How does it affect consumers? It makes imports more expensive for the importer, who then may or may not pass that on to the consumer. There's your explanation. A tariff is an import tax. It's paid by the importer, who may then or may not then impart it onto the consumer. That's it. That's what it is. What about fee structure suggested during arguments? I mean, the opinion, what they ask about during oral arguments is neither here nor there. They're just asking questions to try to learn things. The opinion is the opinion. So don't worry about what they ask during questions. Just worry about the opinion. Yeah. In reality, I think that the importers have only partially been passing tariffs on to the consumer. I don't think they've fully passed it on to the consumer. How they've done that, I'm not sure, but I don't think they've fully passed it on to the consumer. Some of it has, but not all of it has. So, in all cases, I mean, obviously you're talking about all importers, so it's hard to make global statements, but I don't think they've passed everything on to the consumer. I think in some cases they eat in it. In some cases they've taken other approaches, but yeah. All right, well, I think I'm going to go ahead and sign off for now. And I think that's a good place to stop for now. But if, if there's interest in it and I have time, maybe I'll really pick apart the majority versus Kavanaugh and try to figure out who has the better end of the stick. I found majorities. We read the majority opinion in full. I found it pretty persuasive. I've skimmed Kavanaugh. He seems to have some things going for him. So, I don't think I can just do it on the fly. It requires more thoughtful consideration. He might have the better end of the argument. Thomas is just like, well, here's why they can. Like, I'm not even to why they can. I'm interested in what happened. So yeah. All right, I'm going to go ahead and sign off for now and see if maybe I have energy to try to do an Epstein video today or something. Till later, I've been on Civil Law. Cheers for now and goodbye. Keep it real out there, guys.